Nuevas tendencias en la protección de
New tendencies in the name protection, images and likenesses,
NIL.
not images, likenesses, NIL, systems of traditional protection, new tendencies, practical considerations, and models for monetizations for the NILs.
Sebastián Lovera.
Sebastián, Lovera, Ladas, and Parry, USA.
Cristina Hernández.
Cristina, Hernández. Marti, Pérez. Hernández-Marti, attorneys, España.
Fernanda.
Fernanda, Magalha, Kasznar, Leonardos, Brazil.
Moderador.
Moderator, Matías, Noetinger, and Armando in Argentina.
Ahí la tenemos a Fernanda, mira qué bien, justo.
So there we have Fernanda. Very good. Good afternoon. I'm going to be very brief because we don't have a lot of time and we don't want to make this longer than it has to be for the remaining activities.
Estoy aquí en este lugar.
I'm here
y pedí
simply, and I asked to be here.
Ejecutivo.
I asked my members, my colleagues of the executive committee to be here because this topic has a special place in my heart, like ACIPI does. Because in 2002, when I was recently starting my career in this association, they invited me to be a moderator about protection of images in football. And at the last minute, one of the panelists, canceled. I had to be the panelist then, and so that made me, write about something and talk about something that I'm very passionate about.
Llamativamente, tenemos panelistas.
So we have panelists here from Spain, from the US, and Brazil. And at that time, when I had to study the topic, not only was I very surprised about the Spanish scheme in regards to image right, protection of images, something in the Constitution, and Cristina is going to tell you a little bit about the system in Spain, how it's structured.
Lo que era la jurisprudencia de Estados Unidos.
But also the jurisprudence in the U.S.
De los casos y cómo se.
And how deep the analysis of cases was.
El nombre.
And how do you get to not only the protection of the name and the image, but the likeness.
Muy amplio, ¿no es cierto?
That is a very wide topic.
Muy de sentido común también.
And involves a lot of common sense.
Y Sebastián nos va a
Sebastián is going to tell us a little bit more
de los atletas amateurs.
About the amateur athletes.
Ya que la tenemos aquí.
Well, first of all, now that she's here live from Brazil,
nos va a hablar Fernanda Magalha.
Fernanda Magalha is going to talk to us now.
2017, como
she came to carga Leonardos in 2017, talking about marketing in entertainment. She received her title of law from the Universidad Pontificia in Rio de Janeiro,
Franklin Pierce Law Center,
and the Franklin Pierce Law Center in New Hampshire in marketing. She has experience for over 21 years in internal and private practices. She is a counselor for clients about marketing strategies, publicity, brand topics, and a lot of things that have to do with the law of entertainment. She has license to exercise law in Brazil and also the attorney colleges in Virginia and the District of Columbia. She occupied some charges in Coti and Mars, and when she went back to Brazil, she was the chief of intellectual property in the Olympic and Paralympic Committee in 2016, where she was responsible for giving legal counselor, like protection of brand, marketing. She is a member of the Ethic Committee of CONAR, the Committee of Law in AINTA, in AmCham Rio, and coordinator of the rights in intellectual property in the sports of ABPI. Fernanda, the floor is yours.
Gracias, Matías.
Thank you, Matías, Rafael.
I
love you.
Trying to speak Spanish here, so I apologize for switching to English, but it's much better than my Portuñol. I'm speaking to you here from Rio, from home. Unfortunately, I couldn't join you in Punta Cana this year. Hope to see you next year. Thank you, Azipi, for the invitation. This is a subject that I'm very passionate about. Very happy to be speaking on this subject. It's very close to my current practice of work here at Kasznar Leonardos. And it's a pleasure to be able to share a little bit of my insight on the new trends that I see happening particularly in entertainment and marketing practices related to the exploitation of image rights and likeness rights associated with IP-related matters. So I'll switch straight to the matter because I know we're tight on time and we have very good presentations with my colleagues coming up right after I speak. So let me share my screen. Please let me know if you can see well. I think you do. Matías, can you see? Just give me a sign there. Yep. Okay. So today, my goal is to share with you a little bit, well, I guess the commercial context of what we see today in terms of the trends and the ultimate interest around exploitation of image rights. If we think about, the terms that we currently use to talk about digital influencers and the power that image has nowadays, we have to think about the commercial context that we had before social media and that we have nowadays. Not long ago, not before 2012, maybe 15 even, when you had a celebrity coming to our lives and exposing their image for us to consume, you had to find them in very specific platforms and very specific medias, such as a show, a movie, or a TV series. And that celebrity controlled very little of their image and the message that their image and the message that they had to share with us. They depended a lot on the media that they were conveying the message. They depended a lot on the network that, how if their message was being okayed by the channels and so on and so forth. If the celebrity wanted to leverage that channel to commercialize and capitalize beyond their core business, they had to share that responsibility with the movie studios or with the TV channel or with the producer that was producing that content. When we talk about, in the case of an advertising per se with a brand, when we talk about the revolution of the social media platforms, we basically have these celebrities, and nowadays you don't even have to be a celebrity, become media. They become media. They own their own channel. They reach an incredible amount of people, all of us basically, and they become content creators. They create content. They create messages. They share their day lives, and they reach a different level of control of what they want to say, way more creatively than they used to do before social media. So the value that image, that approach to consumers have, it's a lot more impactful than they used to have. But with that, and when you compare, for instance, Matías talked about soccer, right, in the beginning. When you compare their core business, their core practice, in the case of Cristiano Ronaldo, when you compare how much money he makes in his soccer business to his presence in one social media, for instance, in Instagram, how much money he makes with publicity versus what he makes with his contracts in football and soccer, you understand the impact that his presence in social media has. The figures of his social media Instagram account is current. He currently has 355 million followers. This is more people than the Brazilian population, for instance. For sure, more people than the Portuguese population. And you can understand the impact of a simple post of his about a perfume may have on his followers. I find the information about the conversion, as they call in this industry, of what a post that he has on a specific publicity, people react a lot more to a message of his daily life than to a specific advertising. So consumers want to see him on his performance in soccer, sure, but they definitely want to see more the persona of Cristiano Ronaldo than him perhaps playing soccer or definitely posting an advertising for perfume. That's a lot less of a connection when he says, look, I like this perfume. This is the perfume I wear. This is the perfume I like. Buy it. Versus this is the regimen of training that I have. And you should do it too. And this is the product I use on my daily routine. So that has an appeal, just like it used to have when we used to watch a star in a movie drinking a beer or eating a cracker or Doritos in a specific movie scene. But having a situation like that where celebrities or nowadays called influencers becoming media has its legal issues, its legal impacts. And I would like to just exploit a little bit of these issues with you today. When celebrities become media, they have responsibilities as such. I found interesting, or maybe I was surprised to find how short ago we started to call celebrities, and we started to coin this term digital influencer. That's something I use very much in my daily practice nowadays. And I thought it was a lot longer than just 2016, but I found out that, yes, that's the term that started to be used in 2015-16 when the authorities started to realize that celebrities were using their Instagram and social media accounts in general, Facebook and on, to endorse products, not just to share products that they were using and maybe getting, gifts here and there, but to actually advertise products there. This article from the New York Times is from 2016, and they were being, provoking here whether Kim Kardashian, which I'm sure everybody knows about, was actually endorsing a product, or did she like it and was just saying how much she liked it. Kim Kardashian is now well known for her advertising on her social media. And because of Kim Kardashian, several other social media celebrities, the FTC, the American Federal Trade Commission, back at that time, 2016, started a process of educating the market and creating guidelines for advertising with influencers. In 2016-17, the FTC issued a guideline to guide this type of advertising. And so did the European Advertising Standard Alliance back in 2018. And more recently, at the end of 2020, early 2021, the Brazilian Advertising Self-Regulatory Board, which I have the privilege of being a member as an ethics committee member, also released a guideline. Given the impact that the social media endorsing advertising has in Brazil, this is just a picture of the latest data of the cases in Brazil, of the Kasznar cases. And you can see how significant internet cases in Brazil have become. And of the 73% internet, in general internet cases, about 70% are social media related. And I can't tell you, we don't have the number broken down by category of how many of these are associated with influencers, but I can tell you definitely a significant number of these are related to influencers. So Kasznar issued a digital influencer advertising guideline in which basically it creates parameters for advertisers and for influencers in terms of what should be considered an advertising by an influencer. And that advertising should have basically three characteristics, such as the promotion of a product, a service, a cause, or even just a symbol or a sign of something such as a product or a service. Something very difficult to nail down to, the compensation or commercial relation between the brand, the product, and the influencer. It doesn't have to be financial. It can be just a non-commercial compensation, and some sort of editorial interference or control in the text or the message created by the influencer. Once these three steps are found, basically these are the four watch outs that both advertisers, agencies, and the influencers should observe. The influencers are liable, if you will, for the advertising that they post and that they publicize, but definitely the agency and the advertiser, the brand, are more responsible for the content that they try to push through the influencer, and they should ensure compliance by the influencer with the rules and the recommendations of CONAR. One of the most important rules by CONAR is to make the ad conspicuous, so it has to be clear to the public, to the consumer, that that's an advertising, that it can be a sealed, hidden publicity, and that's something that is highly problematic here. You can see from the numbers at CONAR. And so that's definitely something on a daily basis that we see here. But in addition to self-regulatory issues or advertising issues, there are a lot of other issues that come up when you're analyzing publicity and related legal issues related to the exploitation of your personality rights. This is a trend, I think, all over the world, but I just wanted to highlight the most recent ones just for our discussion here. We've seen in the US a lot of these copyright lawsuits against celebrities who have used their own pictures, I guess, third-party pictures, the paparazzi pictures of themselves, but they don't own the copyright because it's been taken by a photographer, paparazzi, but they repost after the paparazzi posts their picture on their website or their magazines, and they got sued by the copyright owner of that photograph. There have been a number of celebrities that got sued by the copyright owner. In Brazil specifically, yes, the copyright protection of the picture stands even for paparazzi's pictures. The number of defenses that I've seen in cases being raised in the US, like fair use defenses, very unlikely to succeed. The concept of fair use in Brazil is very narrowly applied here. The license, the implied license defense is also very unlikely to succeed because the license concept should be narrowly interpreted. So there is no such thing as a broad implied license in Brazil, especially for this type of situation. There is no implied license just because you're simply taking a picture of somebody. Yes, you can claim that, you could claim that there is a violation of your image rights, but given that these people being photographs are public figures, the claim of publicity rights are very, very weak, given that they are public figures. So again, unlikely to succeed, very weak claim. And I also saw a local case here in Brazil where there was a claim of co-authorship between the paparazzi and the artist being photographed. And frankly, while I thought that was very creative, not a very strong argument. We had an actual case in Brazil, and the Superior Court here found in favor of the photographer to be found as the real author of the photograph, not finding any authorship with the person being photographed, with the model, I guess, with the artist being photographed. And this is, I guess, the latest trend with the celebrities in the U.S. hiring their own paparazzi so they can pretend they are being caught by surprise, and then they can repost that picture and retweet that picture instead of being sued for retweeting and reposting paparazzi pictures. I guess the bottom line of that comment is, you know, at least in my world, I always tell my clients, you have to clear your digital content. You have to clear the image that you're reposting. You have to clear the music that you're reposting.
So on the indemnification clauses, usually when we're on the side of the influencer, we try to take good care as to the IP infringement clauses, as most of my clients as influencers, they really don't have a lot of, you know, the ability to control what the brand is claiming as to the product. So we have more robust clauses as to what's being asked of the client to the influencer to speak on behalf of the brand. On the other hand, when we have, you know, programs of hiring on behalf of the brand of agencies or agencies and influencers, we want to make sure that the brand controls have clauses to control the reputation issue. A lot of times these influencers don't have very mature practices or business or what's the best word? Mature artistic support. So one day they are canceled, the next day they're back. So on the brand side, if you're representing a brand, you want to make sure that you have robust clause that can get you out of that contract. As we can see on this example here, you know, this is the case of Molly Sims, who got at least sued for the infringement of a post that she, of an advertising that basically she posted, and she claimed to be excluded from the lawsuit, basically saying that she wasn't responsible for the content of the advertising, and the court in the U.S. said, no, you have to stay, you know, you're responsible for what you advertise. And here in Brazil, we only had one case where something like that was maintained based on the civil code, Article 929, where a small claim court found against an influencer who advertised this fraudulent retail store offer, and the court found in favor of the consumer and against the influencer, saying, look, if you advertise for a retailer which offers a fraudulent offer of a product, you're liable for it. So you have to know what you're advertising. So the point is, you know, you have to be quite careful when you're contracting on both sides, as an influencer or as an ad agency, mostly where I play.
Bueno, vamos a dar un aplauso a Fernanda y vamos a...
Let's give Fernanda a round of applause. Thank you, Fernanda.
Muito obrigado. A continuación,
Thank you very much. Next, Cristina Hernández-Marti Pérez is going to be talking to us.
en la Universidad de Valencia,
Cristina studied law in the University of Valencia,
Universidad Johannes Gutenberg,
also the University in Johannes Gutenberg in Germany. She did her LLM in intellectual property and industrial property
intellectual property,
in the Munich Intellectual Property Law Center, organized by the Max-Planck Institute and George Washington University, among others. She received her doctorate in the University of Valencia about bank infraction. In 2018, in the editorial Tirante Leblanc, she edited the book Determination of Damages.
la llevó a cabo
Her professional formation was done through several offices in Spain, specialized in trade rights and intellectual property,
de sus oficinas en Alemania.
in one of their offices in Germany. Ever since 2012, she's been associated with the IP department in the law firm in Germany.
En materia de propiedad industrial e intelectual.
And she basically bases herself, she works mostly with cases of intellectual property infringement. Thank you, Asibi, for the invitation, Matías, for the introduction. Oh, so, if a CP uses my pictures of Instagram, do you think to promote their next Congress, do you think there will be an infraction there? Well, evidently, yes, there will be an infraction because there is an absence of consent. I'm going to talk to you today about a few topics about monetization of the image within the Spanish law. To monetize the right for image, basically you have this as something that you can use for money, but it's not a patrimony good. It's a moral right that is consented in the Constitution. But at the same time, it is a patrimony right that's not covered in the article number 1801 in the Constitution. The right to your own image, it's independent to the intimacy and owner right. So the use of image for advertisement uses without consent of their owner, it is an intromission without, whether or not that image was gotten in intimacy or publicly. So yes, do you have an infraction there? You have in regards to the use of image, you have a positive one and a negative one. The positive aspect implies that the person that is interested has the ability of basically that person is the one that tells you how you can use that image. The person has the faculty of prohibiting the collection of that image and the reproduction, the distribution of that image. Also, you have other, topics that can be widely and freely reproduced because they are of public ownership. We have image as a social perception from a person. The law considers the voice and the name can be assigned to the rights of image, and the image is the graphic representation through mechanical processes and any kind of reproduction technique. The recognizability is something that is demanded for protection of image rights. It's necessary for the image to be physical, that can be recognizable. The Supreme Court demands that you have to recognize the image. There is no image right. Basically, it's not a fundamental law. In the cases where you don't reproduce a representation of the physical features of the person. So, you don't have image right when it's not the image of the person that is interested in it. In this case from 2001, it was from Emilia Aragon. She invoked the protection of image because she said that the person used some elements from her clothes, some likenesses. Emilia Aragon used to have a very particular clothing, he created a figure. He created a very famous song in Spain. The court dismissed the case because they were not infringing the image rights. They created something else from that image. Basically, you need to have consent, and that is one of the most problematic things about monetization of the image. Who can give that consent? How do you manifest that? What does that entail? What are the conditions or terms or conditions under which you can revoke that consent?
El consentimiento del interesado es el
The consent from the interested party excludes the illegitimate character of the intromission of image rights, of course, without keeping in mind public interest and free speech rights, those are able to exclude the illicit character from that infringement. Who can give the consent? It's very personalized. Basically, a physical person, the owner of the rights, is the one who can give it.
82, es la que se ocupa de los supuestos especiales, el consentimiento.
This law is the one that talks about minors, they're not capable, and in the case of the deceased, the death of the person. In the case of minors and people with disabilities, the consent has to be given by them if the parents allow them. They have to be done in writing by the legal representative that needs to announce it to the law. If the ministry is in opposing to that, they would go to trial. So the thing is that when a minor or somebody with disability is not mature enough to give consent, it's not very precise, but we can observe that when the minor or disabled person doesn't meet this criteria, or the representation of the parents or the legal tutors by themselves is not enough to give consent. Maturity of the minor is a term that also the Civil Code in Spain uses to refer to some features in personality that parents cannot represent their minors that have the enough maturity. So basically the interpretation in this topic is that the control from the ministry, it is only necessary when you are taking kids to a casting or you are going to take their images several times for general purposes. In the case of deceased people, in regards to rights of image, this is very important. Especially when these were people that used to be famous. It doesn't only affect the images that were taken in life, but the ones that can be created post-mortem with artificial intelligence. The images for deceased people, it brings about three questions. Is there protection of images? Who has the right to defend the memory of the deceased person? And what happens with the patrimony, the heritage that can happen after the person is dead? Basically, the fruits of their fame. So, is there a right to the image? The answer is after post-mortem, no. There are no rights to your own image, so you don't have to give consent because that is an inherent right to the person. And the person doesn't exist anymore after you are deceased. After your death, what you have is memory. The defense of the memory and the owner of the deceased person that can be affected negatively as a consequence of things that happen after they are dead. For these cases, the law, basically you have to determine who is going to be authorized to defend the intimacy and the honor of the deceased person. In order for you to do those actions, the deceased person has to assign someone in their will to do such actions. But if they didn't determine who that person was going to be, then it goes to the partner or, whoever is surviving that person. Or the ministry is the one that determines who can make those actions. So basically, the person that are going to be the heirs of the deceased person, they have to be specifically designed to do that. In regards about the actions that can be done post-mortem, they've been subject of the 2016 sentence in regards to Salvador Dalí. He determined universal hair, the state of Spain, but he didn't specify them as being able to do defensive actions. So they created a foundation for Salvador Dalí where they were specifically designed to defend the intellectual rights and the image of the painter.
Que no se había hecho en testamento sino anteriormente, y si existía el derecho a la imagen por bueno, pues la fundación no.
The foundation was not legitimately determined to exercise the defense of the owner of the defense of the image of Salvador Dalí because it wasn't specifically expressed in his will. And basically the rights they try to defend are the exploitation of the patrimony of Dalí and not the protection of his memory. So basically his fundamental rights of personality, since he was already deceased, were extinguished with his death. Something else is the sentence of Parry.
Paquirri agonizando.
The image was Paquirri agonizing in the nursery, and they considered that, yes, they didn't have any rights
Por último,
because the person was already deceased. Finally, what happens with patrimony rights of the image of the deceased person?
que la fama
It is logic to think that the fame this person had when they were in life, it's still reflected after they died. It's something that is not resolved effectively.
quiere
If the heirs
derecho y son las
get that right,
civiles las que resolverán las cuestiones
then it goes to civil court.
pendientes, como por ejemplo
But we have some other things still pending, like, what's the framework, the time that needs to pass before you can defend that?
la muerte del titular, porque
For example, you can still defend it 70 years after the person dies.
80 años.
You can think the time frame is 80 years. That's what I've seen for the ministry to
Entonces,
exercise some actions.
es lo que mejor podría tener cabida en este supuesto.
So I think that would be the best option in this case.
El consenso.
Something else is how is the consent manifested? It needs to be specific, and for it to be specific, the
Forma concreta,
it
explícita,
needs to be concrete, very explicit, and direct.
sino que la voluntad
Doesn't mean that it has to be in writing, but the will of the owner needs to be specified as something unequivocally.
importa resaltar que este requisito
It is very important to highlight that this reform is for the owner of the image,
el cesionario a favor de otras personas, ¿no? Que aquí bastaría con observar requisitos de
and not for other people. And here you can go to the civil code to look about that.
posar, ¿no? Frente a una cámara.
Basically, I can pose for a camera, smiling, I can give my picture, but that doesn't mean that I'm giving consent for the picture to be distributed or published. In this sentence from Barça, Barça visited the hospital, they visited some children with cancer,
De los padres que están de acuerdo
and basically, they got the consent from the parents to take pictures, but those pictures or that consent is not for those pictures to be distributed or published. So the sentence says
intromisión ilegítima por la pública.
that yes, it is an intromission, it is an illegitimate distribution of those pictures.
No admitir, ¿no? Ese consentimiento tácito plantea problemas.
But basically, this consent brings about a lot of problems
Fundamentalmente el consentimiento por escrito.
when you don't have the consent in writing. The best solution for this
Que es
apparently is to apply Article number 2 on the law of the organic law.
altamente recomendable expresar el consentimiento.
It's very recommendable to have a writing and consent in writing, very well written. And if this person denies to giving consent, then you have the consent in writing as a proof that yes, there is a consent.
En ocasiones se ha considerado acreditado
Sometimes
actos de la propia persona y mediante testigos. Por ejemplo, en esa sentencia
you have acts from the person, you have witnesses, and this is considered as consent.
clara de
Because the attitude there was a clear attitude of posing before a photographer, and there were witnesses, and because of that,
informe que
it wasn't just a consent for posing or for taking the pictures, but it was for a company or a pamphlet that was going to be created by a company.
comprende el consentimiento.
Something else we need to talk about is what is comprised within the consent. Legally, the consent has to be specific and it needs to be concrete.
Por el
Meaning, it needs to be limited. It needs to be limited by time, space, and content.
puestas a lo menos posible. Es cierto que los contratos sobre
So yes, it is true that contracts are, mandated to everything that is agreed upon within the contract and to all of the consequences
conformes a la buena fe, al uso y a la ley, pero
in confirmation to the use in good faith of the content.
permite una interpretación extensiva
But
del contrato.
the fact that you don't have a consent, it doesn't mean that you can use that freely.
Un fotógrafo
But basically, in 2006, you have a model. She knows a photographer. She pays him to do her book. He takes the pictures.
puso en contacto con una editorial
He got in contact with an editorial, and he sold the rights of reproduction of one of the photos for a book. In this case, yes, there is intromission to the image because, yes, there is consent to take the pictures. She didn't give consent, express consent for her picture to be published as the main page of a book.
4.
In the sentence in 2004, we have cases of some photographs that were taken from a patient before and after, how this person was before the surgery and after the surgery.
Estas fotografías se publican en un...
Those pictures were published in a book.
Existe intromisión.
And so we think, yes, there is an illegitimate use of the pictures, because one thing is for you to take those pictures, to have the consent to take those pictures between patient and specialist, and the other one is to give consent for the distribution of those pictures in a book.
De los propios actos,
The doctrine of the own acts plays a limited role here.
la doctrina de los
It's not always useful to invoke the doctrine of the own acts, because you have to determine what is the significance of those acts.
sentencia de 2017,
There is a sentence in 2017
los propios de la recurrida con
where they invoke the own acts. You know, they said they used to publish some pictures in Facebook and Instagram, and they considered they could use it because these people were free, you know, they were openly publishing these pictures. One thing is that I can publish my own pictures for people to look at them, and something else that somebody else can use them and publish them and distribute them.
el tiempo, la duración,
The time and duration of the authorization. The owner of the image right can temporarily limit the use of their image, which implies that the right
ocurrido
of cessation of usage
que no se haya
goes beyond the time that has been pacted.
de
In this case, you have to determine how long the session or the authorization is going to last. Of course, nobody is under a contract for life, but you have to determine how long the contract is going to be for.
una licencia con carácter
And if you don't have this,
podría ejercitar la facultad de revocación.
the owner of the image can revoke the consent,
La
based on the law.
imagen debe efectuarse
Given the nature of the
restrictiva,
rights of image,
¿no? En ausencia de pacto,
when you don't have a pact,
la imagen con fines de
and when you talk about image rights,
campaña publicitaria, aun cuando
we can only adjust ourselves. We can only use one ad campaign, even when we are talking about more than one product.
dado por válido que según los derechos, se consideran cedidos por un año. Cláusula
In the law, basically, you give rights for 1 year. It keeps repeating itself in the contract, but it's not like a dogma.
que sea solo cedido por un año, ¿no? Y en el caso de las imágenes
And in the case of images that were taken and reproduced in the framework of a work relationship or, precision of services,
ese consentimiento
you need to determine when that consent is going to be finished once the work relationship is over.
pueden tomarte
Because, of course, when you work for a company, they can take pictures of you for their webpage, for pamphlets, for promotional material.
judicial y
But from our experience with the law, and especially with the Supreme Court, you cannot get to any conclusions about the different things
del
that these cases bring about in the case of
que debe
terminating the work relationship.
la promoción del producto con independencia
For example,
del trabajador.
you can limit the use of the image until the end of the advertisement company, or the termination of the contract is not doesn't represent revoking the contract. In the one in 2002, for example, there is a sentence that considered
Servicios
that the termination of the services is, it means revoking the use of image.
si después
We have another one from 2006 that says that after the work relationship is finished, the worker
la intromisión ilegítima
is demanding a specific amount of money that excludes illegitimate work.
y determinar si existe incumplimiento
And we need to determine if there was lack of compliance because of lack of payment.
español.
However, in the law in Spanish, you can say that when the license is over,
No revoque su consentimiento
the owner of the image doesn't have to revoke their consent,
de la imagen.
because the law gives the right of the image to the owner. Revoking the consent is revocable at any moment, can be revoked at any moment.
Perjuicios. La revocación es una declaración de voluntad
Revoking the consent is a declaration from the owner of the right. It doesn't require a cause. And basically, when you revoke the consent, you are basically not giving your permission anymore for the distribution of the image. At that time, the owner of the image is communicating this to the person that was initially authorized.
Pero debe
It doesn't require a specific format, but it needs to be specific.
ser de manera escrita.
Sometimes, it's better for the communication to be in writing and to be concise to the people that were using the image legitimately up to that point.
No afecta al tiempo durante el cual el consentimiento estuvo
So it's not retroactive. It doesn't affect the time in which the contract was still active.
efectuado, esa publicación amparada por la autorización, el proceso para la publicación ya era irreversible.
But the process for the publication at the time of the revoke of the contract, those images cannot be publicized anymore.
Pues es-
In the example of Ana Rebón, her images were going to be publicized in Playboy.
en otra revista que no le parecía adecuada. Entonces, quiso revocar
Basically, she wanted to revoke the consent, but it was already too late.
de publicación de esa revista.
The process for publishing the physical magazine didn't allow for revoking the contract anymore. And lastly, even when the owner of the image
Que se causa
has to cover the damages caused by that revoke,
a una previa indemnización. O sea, tú
it's not mandatory that you have to pay for damages caused by revoking that contract.
dando esa imagen, sería ilegítimo. Por último, la caracterización y el contenido
Lastly, the character and content of the contract. The first thing I want to highlight is that
específicas,
there is not a specific regulation. This is an atypical contract that wasn't being regulated by the organic law,
el derecho
but to regulate
el derecho fundamental,
the right of ownership for the images.
patrimoniales, ¿no?
But the law talks about the patrimony.
Consentimiento.
In this case,
Por otro lado,
the consent needs to be specific in favor of the owner of the image, and it gives them the right to revoke it.
los contratos de cesión de la propia imagen se documenten por escrito.
Also, they need to do the revoking in writing or through electronic formats.
Contrato,
They need to have a contract and the proof of content
partes. Y en
for each part.
lleva a cabo una regulación exhaustiva.
And they need to have an exhaustive regulation of the rights and regulations from each party and the guarantees of compliance. So through regulation of the contract,
Pueden evitarse muchos problemas
they can avoid a lot of problems that happen in practice.
de múltiples
And as we can see, are causes of a lot of conflicts in the courts of law
y los gastos.
in regards to judicial insecurity and the costs that are associated with it.
Que veo que
This is
tiempo.
the end of my intervention. I think I am right on time. Thank you very much.
Muchas gracias, Cristina. Bueno, a continuación
Thank you very much, Cristina. Next, we are going to
a hablar a
invite Sebastián Lovera.
socio de la firma.
He is an associate from Ladas and Parry LLP in New York. He started working there in 2008 after working in the area of intellectual property in Zacarías, Hernández, and Asunción in Paraguay. He got the law title in the University of Asunción, Paraguay in 2005.
Obtuvo el título de notario.
And also the title of public notary in 2008, then the master's in law degree LLM in the Michigan Law School in Ann Arbor, Michigan in 2008, and he started practicing law in New York in the year of 2009. Sebastián works in the area of brands, dominion, copyright law, working in the creation and obtention of registries,
Tanto en Estados Unidos
protection of actives in intellectual properties, both in New York and all over the world, creation of contracts with global reach in regards to intellectual property. Thank you, Matías.
Primero que nada, quiero
First of all,
advertencia a todos.
I want to let you know something.
No tiene así que
My keyboard doesn't have the ñ, so there are going to be a few words
a otra cuestión anatómica.
that mean something else, not necessarily.
Bueno, quisiera comenzar con
I would like to begin
una pincelada a la estructura de los deportes deportivos.
Talking very briefly about the structure of sporting events in the U.S. to be able to understand
La Corte Suprema de
the
Justicia
context of what we're going to talk about in the Alston case in the Supreme Court of Justice, which is a case that was decided in June of this year. In the U.S., the sporting structure has two levels: the professional athletes that are a part of all of the professional leagues like NFL, NBA, NHL, etc., etc. Those are the professional athletes. They are outside of the scope of this presentation. They have the rights of owner's right, image rights, etc., etc. What we are going to focus on today are the rights that affect the college athletes, the college events, which is the second part of the sporting structure,
popular,
and I would say it's even more popular,
en todos los atletas
where you have all of the amateur athletes, all of the students in college, all of the amateur athletes, like I'm going to talk about in this presentation. These are young people that come out of high school, they go to university, like in the movies are, the recruiters are fighting to get them to their university,
o no gozaban
and how these college athletes didn't have the right
de eso.
to obtain monetary benefits from their NILs, the names, images, and likenesses. Up until very recently, up until July 1st of this year, they didn't have the right to that monetization benefits. So why does it happen? The entity that regulates all of these athletes, we're talking about approximately 460,000 student athletes,
¿No?
almost 500,000.
Todos estos atletas
So all of these athletes are regulated by the NCAA organization, and at the same time, they are also regulated by the universities, and the universities form conferences where they compete in their different sports. The NCAA, in one of their articles, Article 12 of their internal statutes, prohibits every college athlete to be able to gain money with their image or to be able to receive any kind of benefit
estrictamente
that is not strictly academic. And inside of the academic, it's limited basically to tuition,
pago de
meaning the payment of the tuition the tuition basically. Other than that, they have very little benefits. So this Article 12 is the one that brings about all of this controversy and what finally ended with all of these laws and the decision of the Supreme Court of Law.
rasgos.
Generally speaking, the Article 12 is known as the rule, the no pay for play rule. Basically, no college can pay an athlete, a student, to come to their university to play for them in whatever sports,
De
under the premise that
amateur.
they need to preserve the amateur status of the sport.
Muchos atletas
So because of this, a lot of athletes say, okay, well, this doesn't make any sense. We are the main product of these competitions. How is it possible that we cannot not only make money out of it, but our academic benefits are extremely limited to basically tuition?
una
So then,
de
they started a series of challenges or attacks to the structure and the monopoly of the NCAA about the way
un producto que
they act. Everything that was generated by this big product was going directly to the university, to the conferences. They were going everywhere except the athletes, which were the main protagonists.
surgen, como les digo, ataques a
So then they had a few attacks to them, like, we said, one of the final attacks
la justicia.
had as a consequence the decision from the Supreme Court of Justice in July 2021, the Alston case.
Los ni-
The Alston case is not about the NILs.
el ataque viene desde el punto de vista de
It is actually for the anti-monopoly or anti-competition laws. They said that if you have absolute monopoly and we don't receive anything,
que tampoco
the attack is because
beneficio
this is not necessarily about the monetary benefits, but about academic benefits. Basically, we are students.
no solamente no es
We want to not only receive tuition, but we also want some other incentives that help us progress as students,
pase atleta.
right? Not talking so much about the athlete part of it. And some other benefits like,
En caso de
to get some subsidies if we have to go outside for studies and playing, etc. Basically, the Supreme Court of Justice,
a los atletas estudiantes
they sided with the athletes, to the students, the student athletes. And the most important thing about the decision that comes from June 21st of 2021, and I give emphasis to this date because you're going to see that at the same time, you had other things happening at the same time in the state, and at the same time, the NCAA was forced to emit certain decisions and internal memorandums. So the Alston case from June 21st of 2021 basically sided with the athletes, and it changes the environment. Up until that point, the NCAA was firm in their position that the athlete students didn't have any rights to any kind of benefits other than strictly academic benefits, basically tuition. And they said, yes, of course, they are athletes. They have the right to obtain more than what they're getting today. And the important thing about this is not about the main decision, the main sentence by the judge. It's basically by the concurrent opinion of one of the other ministers of the court. Basically, he suggested, or
o por lo menos se interpreta de esa manera,
this is
no se conformen con las restricciones.
He basically recommended the athletes to not be conformist with what they got with this sentence, but they invited them to go beyond this.
Leyes federales y monopólicas.
And he basically gave an analysis of the anti-monopoly federal laws, and he said the structure of the NCAA today is not going to survive. So basically, this is a message that was received by the attorneys
De los demandantes, ¿no? Y
from the athletes,
por todo.
and later on they said, yes, we're going to go for more, we're going to go for everything.
La presentación, pero no importa.
And I'm sorry, I'm going a little bit faster than the slides, but it doesn't matter. So the judge basically invited them to go for everything, to go for more. Once they have this decision on June 21st, 2021, the president of the NCAA,
En un cambio radical de
he went out and said,
estuvimos a favor de los atletas.
he changes radically and said, we've always wanted the best for athletes. We want them to get monetization from their images, and we are going to work in the future to establish clear and positive rules. But before that, he was saying completely the opposite.
En base a eso,
So based on that,
que tenemos esta acción de parte de la Corte, ¿no?
so we see this action from the court, and at the same time, they were telling them that, and the states were siding with the students.
Al nivel federal, ¿no? Los estados comenzaron a emitir
So the states
a favor de los atletas.
started basically dictating laws in favor of athletes, saying that any type of restriction to the benefits that the athletes can receive from the NILs is illegal.
En el 2019,
And in 2019, California is the first state that kicks the board, basically, since June 2021. Going back to 2019, they said, no, we don't have any reason here
eso hace 20
to not allow the main role players to have access to the benefits. So they launched a law that basically establishes that all athletes have the right, to
los atletas
have the benefit that their NILs generate. They have the right to hire managers or representatives that guide them about this. They established some limitations. For example, they cannot be sponsored by contaminating industries like tobacco, alcohol, betting companies. Basically, they determined all of the rules that are going to be adopted by other states.
en California.
In 2019, the state of California dictated that in 2019, but we are going to defer this until January 1st, 2023, to allow all of the colleges within the states of California
Su regulación y estatutos
can have enough time to adjust their internal status
derechos por parte de sus atletas.
so their athletes can have these benefits. From then on, you had a domino effect. All of the other states say, okay, well, California is one of the most important and rich states in the U.S. They have this law. Well, let's do that as well. And it got to a point where basically
26 de los
26
de otros estados
other states
leyes distintas, con la salvedad de que
also launched different laws.
la pelota
And yes, it is true that California was the one that started, and they deferred it until January 1st, 2023. They said the other states say, okay, no, we're going to do it right now. We're going to do it in a year. And so 16 of those 28 states established the effective date as July 1st of 2021. Remember the date of the sentence, July 21st, 2021. July 1st of 2021, basically when the NCAA was against the wall. Now he comes out and gives this declaration that, yes, we are in favor of that, we are going to help you, etc., etc. So now that they are against the wall, on June 30th, he does an internal voting where they said basically, okay, so each state has their own legislation, this is a disaster.
le pasaron la pelota a los
Basically, you know, they gave all of the power to the states. So now all athletes,
la efectividad del artículo 12 y
now the Article 12 is going to be effective from now on, and all of these athletes can monetize their NILs under the condition that it complies with the law of their own state. For example, if they're in California, they need to follow the California law. If they're in Michigan, they need to follow Michigan law, so on and so forth.
no esta legislación también pueden hacer lo que quieran.
And basically, if you don't have this law in your state, you can also do whatever you want. Do whatever you want
Se estudia y se promulga una ley federal.
until we have a federal law. And why is it important to have a federal law? Because they are doing internal lobbying for the federal law to basically establishes, first of all, to resolve this disaster that they have now when you have 26 or, you know, almost 50 different laws regulating the same topic. And obviously, they are lobbying to have the control, again in their hands.
El 30 de junio
So this is what happened on June the 30th when they launched this notification, this promissory note, basically leaving without effect Article 12.
estamos hablando 30 de junio
From then on,
la campana había un
July 1st,
estado muy importante en cuanto
we had the state of Pennsylvania, which is also very important when it comes to student sports. Their law started being effective on June 30th.
el listado de estados
And here we have the list of states, 16 states
primero
that started using this law on July 1st.
y otros dos estados también promulgaron
And other two states
entrada hasta más
also approved the law, but they also deferred the effective date of the law. And we have 5 more states that are studying this law right now. So we got to the point
genera todo este nuevo negocio.
of July 1st, opening up more opportunities for the athletes. This is very favorable for athletes because these athletes have a very important reach. Not all at the national level, like not all of sports are televised nationally. They are not all accessed by the entire population.
Latinoamérica
But just like it happens with soccer players in Brazil, for example, people that come from the favela, or in Argentina that comes from poor sectors, also student athletes, they don't necessarily have a lot of resources.
liberación a
So
tienen de utilizar y monetizar sus
this freedom that they now have to use and monetize their NILs opened more doors to a lot of athletes
no son muy
that, yes, you know, maybe they are not very attractive to be sponsored by Coca-Cola, but they are attractive for to receive sponsorship from the local barbershop or the local dealership. And that, of course, that's not going to generate $1 million to them, but maybe $10, $15, $20,000. You know, even if it was me, I don't know, maybe a haircut for me, yes, I would gladly take it at the local barbershop. But anyways, this is the important thing
y que
that brought this decision from the Ashton case, and that made the NCAAs to basically open up the doors for everybody to be able to get some benefits from this.
¿Cuáles son las similitudes?
So, what are the similarities in between all of these different states, these different laws from different states? Similarities that they allow all of the athletes to use their images and to receive benefits or monetization. They were able to hire agents or representatives to guide them. They could get. They prohibit sponsorship from toxic industries. And also prohibited the no pay for play. It didn't alter the basic premise that nobody could be paid to play in a certain college. And a lot of them, not only colleges don't have to pay or cannot pay the athletes. They also cannot pay an athlete to go to a certain college. Me, for example, I am a fan at a university. I have a lot of money and I love this player. And I'm going to say, okay, so I'm going to offer this player a card to sign a contract with my college. That is not allowed either because that is pay for play. Now, there are differences also between the different laws, and this is where you want the federal law to finally put an end to all of the differences in the laws state by state. The differences are, for example, the obligation to report, the obligation from the students to report the university on any type of agreement they have about the NILs, the obligation from the agents or representatives to be registered with the state or the university. And also, there are some other restrictions, like, for example, the athlete cannot enter a sponsorship agreement with Adidas if, for example, the university already has a sponsorship contract with Nike, which is a competitor. So, like I was saying, this is the main purpose that the NCAA wants. It's basically to find a federal law to regulate all of this and to put an end to all of the different regulations that are nowadays into existence. Recently, a few weeks ago, in November 15th, there was a convention that was organized by the NCAA where they talked about a possible modification of their internal constitution with the purpose of making it adequate for the athletes to basically obtain some monetary benefits from their NILs. Right now, we have a few federal laws or, that are still in the works, some laws that are still in the works with Congress. There are four main ones that are the most relevant, but they all go back to the Alston decision. Basically, it moved the scoreboard a little bit, and it is believed that at the end of the day, they are going to be working on another law that is going to be modified. They're still working on it at the plenary. And they're going to try to take some points from each of the law projects that were presented from some Republican senators, from some Democrat senators, and there is a project that was bi-party, presented by both parties. But like I said, almost all of them go back to the Alston case decision from June 2021. So the effects of the NIL in in college sports, like I said, as of July 1st, 2021, all of the athletes were given the freedom to obtain this, and now we have concrete cases. For example, when I was doing the research to prepare this, I saw that a lot of them were basically already had their finger on their keyboard, and basically they wanted to go, everybody wanted to go to Twitter and Instagram to see what was the first athlete that already got the first few benefits. There was one actually that happened at 12:01 a.m. and another one at 11:48. But they both claimed they were the first. The effects in regards of the numbers.
Tanto a nivel profesional como estudiantil.
Both at the professional level and at the student level, the football and basketball are the ones with the most benefits.
La mayor cantidad de actividades
the bigger amount of activity.
Vemos que número uno está el fútbol.
Number one is football. Second one is male basketball. In regards to compensation, meaning benefits per sports, You also have football and basketball, which clearly indicates that those are the predominant sports. In my case, I went to a very important college of American football. The money and the craziness that this generation students is from another planet. So this is not surprising to me. You also have March Madness, which is a very important and attractive tournament. Basically, the entire country is, expecting watching the television, and that is when the economic repercussion that it creates with students is very big. So we are going to see multi-millionaire contracts in March. Another one of the effects and the importance. Remember that not all student athletes are going to be professional athletes. And if they get to be professional athletes, not all of them are going to be successful. You can have one that is going to be injured, their physical build is not going to be the same. It's not going to allow them to play at the professional level, maybe. So these changes give the opportunity to these athletes to be able to receive some fame and influence today through social media when they are at the top of their career. Because, for example, the star of my American football team when I was at college, everybody, he was a star. Everybody wants to be next to him. He went to the draft. He was chosen, I don't know, in the fifth pick. He had a very small contract.
De contratos donde se le paga a los
We're talking about a contract, the rookies get paid a lot for objectives. For example, if you play X amount of plays, you're going to get paid X amount of money. He was a rookie, he didn't play a lot, and then he retired. Right now, he is an assistant in one of the universities. But after 10 years, he was forgotten. He never really had the opportunity of really getting the benefit that fame generated and that influence that he had in the other athletes. In my case, it wasn't only in the country or the city, but at the country level because of repercussion and the level that this college had in American football. Where do you see the biggest activity nowadays about this? And we go back to the statistics. Obviously, social media is there, the posting content. This is actually one of the first activities that were paid, where student athletes go out to sponsor local companies. For example, we have here the image. This is one of the ones that claims to have one of the first contracts. He is with a local company. And as you can see, he has a shirt from the owner of the store. And that sponsor generated $10,000 for him. We're not talking millions of dollars, but this is a student athlete that he's a student, and $10,000 can actually make a very big impact. Because remember, a lot of these students come from very humble beginnings. So whatever amount of money they can get is important for them. Another thing is that it basically brought more equality between males and females. You always hear that male athletes are more attractive for companies, and they always generate more noise, more money. But here with social network, we see that also the women are at the top of the rankings of student athletes with more revenue. And finally, you don't only have sponsorships. This player said, okay, if I don't have a sponsorship, I am going to create my own clothing line, and I'm going to monetize my own influence about this in the students in my college. And so he launched his own clothing company. Thank you very much. This is the end. Thank you for the participation. Thank you, Sebastián. And I think because of time, we are not going to have questions. We are going to go directly to the other panel. Thank you very much.